Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law. Please subscribe to our channel. If you are separated from your spouse, and we get inquiry about this a lot, people get married, they have a falling out, they're still married, it's 10 years later, they're living in different places, they're still married, but separated for many years. Well, what happens if while you are separated, somebody dies? Let's say you pass away. You're still married, so your spouse, as it were, has the law of a surviving spouse. A surviving spouse is going to take the bulk of your estate. So if you're worried, well, I have kids, think of it this way. You were prior married. You have 3 kids. They're adult now. They're on their own, but they're your children, and you want to make sure that they're included in your estate. Well, then you got remarried. Now you're married with this person for a while. 3 or 4 years later, you decide it's not working out, you leave. And now it's 10 years later. If you die tomorrow, that spouse who you have been estranged from is going to be your surviving spouse and is going to inherit as a surviving spouse. Even if you had a will that predated that spouse, so the will says I leave everything to my kids. If you die married, and that will doesn't include that spouse is going to have the right to take a share of a surviving spouse, and that share is determined by statute. Roughly speaking, if they're going to take basically the first X amount of dollars, it's either 100 or 150,000 of the estate, and then they're going to take 1/2 of the balance, and the other half of that piece, that's going to go to kids. In other words, the bulk of your estate is going to be going to that surviving spouse who you cared so much about that you've been estranged from him or her for years, okay? Now that's not likely to be a result that you want. Therefore, here's what you should do. You should make sure that if you want to create a scenario where your estranged person in your life doesn't inherit, you better file for divorce. That's what you need to do, because this is going to be so much more costly to the estate than the cost of a divorce if you just leave it be. Like most legal things in life, neglecting them tends to not improve the situation. It usually causes it to be worse. This is a perfect example of that. Obviously, it's going to depend on what you have, what will be in your estate. The rules that I talked about, the surviving spouse taking a spouse's share, that only has to do with things that are in your estate. You could have things that you own but are technically not in your estate. So there's a lot of technical rules about this. If you have any questions, of course, reach out. We'll be happy to discuss it with you.